subscribe though. Ah, here we go. Hey, Kim.
Hey.
Glad you could make it. I was just gonna give Shannon a brief intro, and then we could turn to talk about what I sent out late last night. Oh wait, I think I shared the wrong thing. Hold on. Or did I? Okay. So from last week, I know a lot of the discussion was around not putting too many barriers in place to becoming either a certified law student or a supervised provisional licensee, just because we want to make sure there's folks are able to access these paths. Folks that historically have had more barriers than others are able to access these roles. Competition became different in terms of like oversight or requirements of actually being in a law student program. I think a lot of that is motivated from the folks in this group have established law student programs that are fairly robust. And so understandably, there's resistance to putting a lot of guardrails on that or requirements on that because you have a system in place with a lot of oversight over law students. But through the competition, we realized, if we are creating a position or a paid position for law students, this opens up to a lot more practitioners or firms or organizations to be able to host law students. And so what guardrails or expectations should be put on these programs to make sure that they are meeting client needs, and also, meeting the goals of a law student program. So with that in mind, I kind of tried to look at a wide range of other jurisdictions nationwide to figure out, in other law schools, to figure out what are the expectations of other jurisdictions put on these programs that are different or more than Oregon's, which for the CLS program is fairly minimal in terms of getting certified. And so I included a lot of what I found, everything I found in this list, not because I think everything on here should be included, but just to kind of give a survey for discussion and to talk through and see what may or may not make sense for our programs, for our purposes, or what you all thought. So I don't know if you all had a chance to look through this, but we can kind of go through what is in here so far and get preliminary thoughts. The role definition is basically stolen from the Supreme Court definitions of what these roles are. So the qualification standards was pretty, based on what this group thought, pretty limited because you didn't want to put too many barriers to entry to qualify to be a law student besides you've been certified. And there are some places or some thoughts to have it be limits around where you're going to be employed. What is the type of organization? It is an organization that is primarily criminal defense or does this much court-appointed work or things like that. So it's not, a civil firm that is going to, have the law student do some appointed work or something like that. If that's something that we think should or should not be a part of this program. Like it's the first point of discussion. Have you all had thoughts? I know you all work in nonprofits, so we don't have the private attorneys here to give thoughts on that combined or mixed caseload. Do you all have thoughts on if there should be limits on the types of organizations certified law students work in? A starting point? Or should we leave this until we have more of the private attorneys that come from other perspectives to comment on that? So I'm just gonna maybe Let me highlight that as something to come back to later once we have those folks here, and they might join later in the meeting. So the meatier part is requirements around who can be a supervisor for a certified law student. And a lot of this honestly might overlap with the supervised provisional pathways. And that's also a discussion of what are the differences going to be, if anything. So we had talked last time about minimum amount of time to be practicing to supervise a law student. And we thought there's a window, 2 years not enough. If you go over 5 years or farther away from misdemeanor practice, it might be too much. So we landed on at least 3 years, which is the same as the supervised pathway. There's a question if we want to have any expectations around specific criminal defense practice and specific attorney qualification. OPDC qualifications tend to follow the length of time you've been practicing and having trials, but we don't have to marry it to that. But so long at misdemeanors with trials, you go to minors. So long at minors with trials, you go to majors. So we can shoehorn in public defense experience with AQ level by saying they need to be at least major felony qualified. That's roughly 3 years. Or we can just say criminal defense. What do you all think is an important level of experience for someone to have to be able to supervise certified law students? Shannon, I see you nodding your head a lot.
Yeah, I really agree with the major felony qualification. I'm thinking about like the exposure to the sentencing guidelines and just having a strong sentence practice seems pretty essential. Even if you're guiding CLS or brand new misdemeanor attorneys, you need to have that. If you're doing the review of their case, you need to have that experience.
I agree.
And I believe, is the SPPE supervision, and I know this is just for CLS, but does it say 3 years of practice in Oregon? I think I remember seeing that, but
3 of the last year, let me pull it up. Three of the last 5 years, I think, in Oregon. An active member of the bar in at least one jurisdiction for at least 3 years. Let me share the screen. I have this over to this. Not great at sharing. You've been an active member of the Oregon State Bar for 2 years preceding, and you've been an active member of the bar in at least one jurisdiction for at least 3 of the last 5 years. So something about that you like, that you think we should mirror for, we can just steal that. I mean, oh,
yeah, I think it would be make it cleaner if it's just the same, but
okay.
I mean, I don't really understand it. So that just means like 2 years consecutively in Oregon.
And somewhere
for 3 years. I mean, what? So 5 years if you're not from Oregon? Is that, and then, okay. 3 if you're, or 2 if you're from Oregon?
Yeah. Yeah. Can you see, are you looking at the certified law student definition? Is that where you're, I can't tell what I'm sharing right now, to be honest. Okay. This is my nightmare. Okay. Okay. So we can remember the bar. So we can just steal that.
And do you want to maybe put like major felony attorney qualification instead of experience?
Yep. Sorry. Okay. So we want to do member of the Oregon State Bar. Or you think we should just steal or take the entirety of the provisional licensee supervising attorney qualifications, the 2 or more years preceding in Oregon, and then 3 of the last 5 as an active member of the bar anywhere? We can just take that for right now for ease.
I think it should be in Oregon, just because it's going to
Okay.
be an Oregon bar licensure that this person is earning.
Okay, so as an active member of the Oregon State Bar for at least 3 of the 5 years preceding. And then major felony qualification. And then these are the ratios I've been able to find. This was another thing that I had said that I would come back with for this meeting, was discussing what are the supervision ratios. And it was interesting the way that Wisconsin broke it out. I found it was pretty interesting in terms of it put it in terms of how much time is put towards the supervision. So if you are over half time just supervising, then they say you can supervise 10 law students. But if it's less than 20 hours a week, they put a 5-student maximum supervisor to student ratio.
I kind of like that. I thought that made sense to set a time requirement on it.
Mm-hmm. And I think that'll fold into eventually, it's not part of the conversation, but what supervision or like a conversation about funding and things like that around supervision and training, which is already part of the nonprofit office model, would go into that. Washington follows more like what we had talked about last time in terms of taking into account the size of the office. So they had 1 intern for private practice, 4 for legal aid or public defense per attorney, and then 10 for clinic.
Mm-hmm.
And maybe a combination of that is appropriate, because the conversation last week did talk about how private practice didn't have the capacity to supervise as much. So maybe a combination there in terms of 1 intern per private attorney, like if you're at a private practice. And then if you are in a nonprofit, it varies on how much the FTE, the supervisor, has.
Yeah, I mean, it's hard for me to imagine a private firm that has someone who can be dedicated to over 20 hours a week of supervision, and that there isn't, without a substantial number of attorneys, or, that would be an odd setup, I think. But I wouldn't be opposed to, a combination of the 2 standards.
Okay. Something that we can bring back to our private practice friends when they join us. Right.
This is like 10 CLS students maximum.
This is realistic. This is, you know, the ratio for
That seems
supervising attorney.
like, yeah,
So
that just seems so high as a maximum.
I guess if that is your only job, if you are just supervising them, if you're just spending more than 20 hours a week just supervising them.
Yeah, your only job was to supervise CLS. I would still feel bad for the person that's at 10 CLS. I'm looking at Tim Davis right here, but like, I would still feel like they had way more work than they can handle, but.
And so Wisconsin does 4 per attorney, even if they're in a public defense or, you know, nonprofit office, and it's only if it's a full-time clinical, that's 10. But last week, Joe Prini Abbott said that best practice for clinics is 8. So, we can compromise here, but I know that, you know, and y'all's offices have different ratios too that you practice with. So,
yeah, and I think it's sort of interesting to me in that all of these standards rely or assume a single supervisor. Like for the NPD program, we're about to start with 10 CLSs in like less than a month, and it'll be pretty much my full-time job, but I also have like Thalia, Sadie, will play a substantial role in supervising those students as well. It's a little bit tough because at the end of the day, it's just one person's bar number on a case, but I know that in my experience, at least, having more than one supervisor makes an enormous difference in like my own personal capacity in terms of supervision. And none of these things seem to really address that.
yeah, I guess, how do the other offices deal with the supervising? Is it more assigned one to, you have one supervisor? Is it crowdsourced or shared, depending on caseloads, or how do you all manage that?
You're kind of a hybrid. I mean, it's like one supervisor, but then the law clerk might be paired with like a group of 3 or 4 attorneys. I don't want to make it more complicated than it needs
I know.
to be.
Okay.
So I think yeah, clarity is helpful, and just, you know, being able to assess what, you know, where you fall quickly. But I wonder if doing some kind of hybrid where it's like, you know, if you have a supervisor that's at least half time dedicated and a certain amount of attorneys, then you can have up to 10 law clerks in the, you know, certain amount of attorneys in the firm.
Okay.
I mean, it could also, maybe if you had, similar to that Wisconsin rule, where if you had, that would, I don't know what the wording on it would be, but something that would be a little bit, allow some flexibility if you had more than one supervisor each able to dedicate, you know, over X number of hours to supervision. Basically, certain number of CLSs per supervising attorney. I don't know.
Yeah, I mean, currently, should we limit? I mean, supervisor, I think, has the limited role of whose bar number is on this, right? And so that is different. It's almost like if you have backup, I think is very different than this 5 have one attorney as their bar, you know, who's overseeing them or who's responsible for them, and these 5 have this attorney that's overseeing them rather than one person over 10 with a backup. I think those are different structurally. And so I don't know.
I think if I can just chime in real quick. One of my concerns is that when we set these maximums, history has taught us that comes to be an expectation of what you're required to do. So if we're receiving potentially supervision funds in the future, but don't have 10 students because say we have 8 really high need students, or I don't know, right? Like that, there's something that happens. That maybe they would say, okay, then you're not a full-time equivalent supervision for CLS because you're not carrying 10 students.
Okay.
So I would like to mirror best practices because I think that's where we should be heading anyway. So I would advocate for an 8 student maximum per full-time 1.0 full-time equivalent clinical supervising attorney or something like that in a nonprofit office.
Okay.
You know, I think right now, like the ratio, because if you're thinking about the ratio, those are for students. These are, I mean, this is like your hand is always tired from holding other hands. And if the equivalent right now is like best practices 1 to 10 for misdemeanor attorneys, it would make sense to maybe lower that ratio for students.
So I know last week we were told 8 for clinics. Wisconsin does 4. Okay, so maybe we put somewhere between 4 and 8. And you can get a wider swath of input, or
Doesn't Wisconsin do 10?
and if it's a full-time clinical supervising lawyer or a member of faculty of an
That's for
approved law
Washington.
school for a clinical course. Oops, my bad. You're right. It is 10 if it is more than 20 hours a week spent supervising. I think Shannon's point is the current supervision for overseeing other attorneys is 1 to 10 is the current guidance from a PDC, and that's based on NAPD best practice. So theoretically, a law student needs more supervision than a practicing attorney.
I think setting 8 as a maximum per supervising attorney makes some sense. I'd want to push back if it was less than that allowed per supervising attorney, especially in a setting where you have, at least the way we do it, where we have additional mentor attorneys assigned to each person, and we have so many people for CLSs to go to. That would, I think, if it was down to like 6 per full-time supervising attorney, I think that would, at least in the MPD context, I think it would unnecessarily limit our program.
Shannon, Kim, what numbers do you envision, or what do you practice in your offices?
We're just talking about CLS, right? That's the only.
Yeah. We're even just at CLSs right now.
What would be the like? I'm just trying to think. Would there be any other additional reporting requirements for CLS cases? I guess I'm just trying to gauge the administrative, not just the supervision, not just the training, but the administrative lift for how we're reporting to the agency.
I don't think there's any reporting unless we create standards like that. You have to file on every case a notice and consent.
Okay. Well, why don't we, for right now, leave it there? We have difference of opinion, somewhere between 4 and 8 students per a full-time supervisor. There's potential we could base it on the size of the office, like how robust like other supports there are in place for a CLS, depending on the size of the office. So let's leave that there. Okay, and then this is the meatier bit. Also, it's performance standards, and so in terms of law students, obviously they need to adhere to all of the rules set forth in the Supreme Court's appearance rules. Things that happen that are required in other places, or things that potentially need to be just called out for importance were added in here. And so I'm curious what you all think about requiring these things. Securing and filing with the court written informed client consent on every case, including whether or not a CLS may appear with or without a supervisor, because the Supreme Court rules is unclear. It just says you need to get permission to appear with or without a supervisor present. And so I could see some delineating what a client is comfortable with, and obtaining informed consent on that. Obtaining consent from the court to appear in each case. That is something that is required by the Supreme Court, but I think is not done in practice in a lot of jurisdictions. And we have seen that happening across the state, where the court doesn't realize they have a role to play in accepting a law student's appearance in a case. And potentially this could be an outside control to make sure that there aren't cases being assigned to law students of especially, vulnerable or at risk situations, or cases that are inappropriate for a law student. Requirement to disclosing or signing what forms or petitions they assisted on. Something that some other jurisdictions require more specifically than we do. Like if the law student is the person that went through the plea petition with the client, making sure that is clear, even though the supervising attorney also has to sign it. And then there were some requirements. These came out of Washington, D.C. that really limits the number of trials that can be set. So a law student cannot have more than, for them it was one trial in a day scheduled. And then there was a companion supervisor rule that a supervisor couldn't have law students with more than, I think, so many trials set on the same day, also to make sure they were available in the same for all of them. So those were some things that I saw in other places that I wanted to offer for our CLS standards. And so I'm wondering if there's any there that you all think are over the top, inappropriate, should be more, or what you all think.
I think that makes sense. I think I could see that helping our conversations with the court. I know in Multnomah County, the judges like to stack misdemeanor trials with the same attorney, even when we've fought against it. I could see this being helpful as a rule for us to be able to cite to the court that, the idea of a CLS already preparing a single trial is a lot. The idea that they'd have to prepare more than one trial for the same day is crazy. At the same time, I do think some of that needs to be kind of that discretion needs to be sort of front loaded on the office, where to prevent the CLS from being in a position where it would be even possible for them to have like multiple trials scheduled on the same day. But I certainly wouldn't be opposed to a rule that just prohibits that from happening.
I agree with that as far as like for the CLS side of things. I don't know that I think we need it on the supervisor side of things, just because I'm thinking about like if you've got a couple law clerks and they jumped on a trial with another barred attorney, but not the supervising attorney, that you could have two law clerks in trial on the same day, where you might be available to bounce between courtrooms, but there is a barred attorney there with adequate experience.
Because we could make it in terms of quote unquote unsupervised trials, right? They're going to be can take it or head no, like a limit, like an assurance that there's a supervised attorney in the room, for every trial, and of a certain level. What was that?
Is there any room for us to, I'm just thinking about like, within the court file, is there any like prejudice that would occur to a client if there is public information that this is a law student versus somebody who's licensed?
Well, I think, well, it's already required that it's filed into the court case, client consent to have a law student appear, represent them on a case with or without a supervisor present.
Yeah, I'm wondering if like, it doesn't say how it should be filed though, right?
Like if you could file it confidentially.
Right.
What's the, is there a concern that a DA would, or the court would use that against the person?
Well, I mean, I think the court would all know who your CLSs are. I'm just
Yeah.
thinking about like, you know, from an equal protection standpoint, if there's anything that can be done, you know, I wouldn't want this person or somebody having a jury trial and them thinking, oh, you know, all they're worth is just a student to represent them, not an actual attorney, and to have some sort of prejudicial impact. That's where my thinking was, but that could be for another day. I'm not really too hung up on it.
I'll find the exact language.
Just to, I think it was Kim's point earlier, it would be, I think it would be nice if there was some language that, I don't know, maybe afforded some flexibility when there is a qualified barred attorney present for the hearing, even if it's not the, you know, named supervisor. I think that could go a long way to, I think, probably alleviating some of the concerns that these rules generally address, as well as allowing some of these programs that currently exist to continue.
Okay. Some places are very strict. There's a lot of jurisdictions that never let law students appear on the record without a supervisor ever, or require that if this is a hearing with any testimony, then a supervisor must be present in the room. I can't remember which jurisdiction it was. There's one that has, if the supervisor will not, if there's not going to be a supervising attorney appearing with the CLS, they are going to be available within 30 minutes. If the client wants to consult with them, or if anything comes up, then there's going to be somebody that's available within so long to come to a hearing or to come to trial.
Christine, sorry, one other thing, when you wrote, except when other supervising attorney present, I wonder if people have any issue with it, instead of being a supervising attorney, like qualified licensed attorney, because we've already defined supervising attorney as needing a certain minimum amount of experience. I know that for us, we've had very good results and experience. I mean, I'm sure we could do better, but when we have like misdemeanor attorneys, that it would be their case normally, and then be able to put a CLS as like a second chair with them, that person wouldn't meet the standard for a supervising attorney that qualified, you know, attorney to take that misdemeanor case because they haven't been practicing for long enough. But I don't think it would be, as long as the supervisor is around, necessarily an issue that person doesn't have 3 years of experience.
Well, and so part of this was limiting how many of your law students could be in trial at once, right? And unless they are with some sort of qualified attorney, do you think having 3 law students with 3 misdemeanor attorneys all in trial at the same time is feasible?
I mean, I could tell you it's happened. It's happened multiple times.
A lot of things have happened in public defense. in
Oh yeah,
Oregon.
no, I agree with that completely.
Not putting that on par. I'm just like, so
Yeah.
what's the ideal, right? In terms of, you
Well-
know, fine, you can have 3, but no more than 3 of your, you know.
I think 3 would be fine. I do think 3 is manageable, especially when you take into account the varying involvement of the CLS, and just kind of the nature of trial work generally. I do think 3 is doable. Yeah, but that probably makes sense to not to limit it to less than that. Some or not more than that. Some of this also comes down to just sort of difficulty in managing that. Like that is,
Yeah.
you know, we got if you have a program with 10 CLSs, we don't give our CLSs many cases at all. They have like 2 cases at a time generally. But even with that, the way the trial readiness docket works, at least in Multnomah County, it would be very difficult to manage the trial settings of all of those cases, to make sure we're not exceeding some limit. Which I don't know if there's a real great solution to that, but that just seems like something that'd be very difficult to get ahead of.
I totally agree with that, especially with using the phrase like "will not schedule more," because also if we're not allowed, so many get like dismissed at call or they plead out at call and don't actually go to trial. That if we limit the amount, then the reality of it is that clients then are going to have their cases pushed out a little bit further instead of being able to resolve sooner. So I think it actually harms clients to put too much of a limit on that versus what we're trying to do, which is protect clients by making sure that they are getting adequate supervision.
And so, and so you all tell me, what do you think is the appropriate balance? You know, I mean,
there be a limit on like defining where the CLS is the lead person or lead legal representative, like 2 different categories, because I see like
maybe it's more like ensuring that a CLS in trial has a certain amount of support, whether it's with a lead attorney of a certain level or an available supervising attorney or something like that.
Yes, and I think that allows the offices the flexibility, and because it's our careers on the line, we can flex it and then make sure that I think it would be helpful that the supervising attorney like approves of like, if they're hopping on with a misdemeanor attorney, maybe it's a misdemeanor attorney that has a lot of misdemeanor practice. And it's not like a misdemeanor attorney that's been practicing for like 2 months, So maybe kick it back to that's in the supervisor's discretion, but it should be approved by the supervising attorney, like signed off somehow.
Yeah, I agree with that for sure.
Okay.
I don't know exactly what that would look like, but I know that we are very discerning in terms of which misdemeanor attorneys can be with the CLS in court, and I think that probably does make a pretty enormous difference.
Okay, so something like will ensure that, I mean, there's something in here, we haven't gone through these above. Ensure, where was it? Just one, take reasonable steps to ensure intern is adequately prepared and knowledgeable to handle any assigned matters performed outside of supervisor's presence. And so maybe dovetailing on that and ensure that they have adequate, because outside the supervisor's presence, and ensure they have adequate oversight or.
How about adequate oversight from a licensed attorney, like that qualified to take that case type, or? And sorry, but Christine, I got I got to go back to trial prep in just
Yep.
a couple minutes. Just want to
Yeah. Well, let's, I'm just gonna put in, enough oversight during trial by a qualified attorney. I'll fix that up. So to run through this a bit more in terms of just to get gut reactions. So these are all taken from, I don't remember anymore, but supervisor will provide training to all interns under supervision regarding criminal defense practice as well as rules of professional conduct and how they relate to their limited practice. Direct supervise review the work of the intern, ensure clients represented are informed of the student status in advance of representation, review and personally sign, I bolded that because I have stories, review and personally sign all correspondence providing legal advice to clients, all pleadings, motions, briefs, and other documents prepared by intern. Those were meshed from two different standards. We've had examples of, I think, law students with the ability to rubber stamp attorney names onto motions that got filed in different places. And so wanting to put the onus on a supervisor that they actually have to personally sign it and not just, you know, the system lets you populate things and onto a motion. You already went through reasonable steps to ensure they're adequately prepared, meet with them. And this is again, word for word from somewhere else, meet with the student in person or by phone a minimum of once a week to review cases being handled, provide feedback on performance, provide guidance, instruction, answer questions, inform the bar. I said this should probably be OPDC. Promptly if circumstances arise that cause supervising lawyer to have concern about the moral character or fitness, the practice of the intern. And then we just talked about this. Supervisors must be available, but not necessarily physically present if a client wants to consult with them, or they must be physical, or it's anyway. So what do you all think of these roles of the supervisor overseeing a law student? Understanding that we are going to tinker with the trial oversight piece. Any of this seem unreasonable to put on a supervisor? It seems like too much.
I think the like reviewing of all correspondence, you know, like letters and stuff like that, but a lot of our letters are, some of them are pretty standard, right? Like they're kind of stop initial letters and things like that. So to have the supervisor having to personally sign it, I'm not sure if that's necessary, but yes, for things that are filed with the court, I do
Does the
think
carve
that
out
those,
for correspondence that provide legal advice, like that carve out, that needs to be reviewed versus not all correspondence?
Makes sense. I don't understand point number 2, direct, supervise, and review all work of the intern. I don't see how that's one, possible, or two, I don't even know, like, that just doesn't make sense to me. If the intern does, there's a lot that we do in terms of work, you know, that I don't think is necessarily even really subject to review.
It might be redundant with the rest of it anyway.
Yeah.
If you're doing the other things.
I would say like, because this is for the supervising attorney, right?
Yes, for a law
I
student.
think I really like the DC's language was like kind of out there, but I really liked how it said is responsible for the work of the CLS, or I think that's appropriate.
Yeah.
Because there's some CLSs that we've had where I'm like, you are better than I was 5 years into practice, and I feel pretty comfortable with them doing stuff. And there's other ones where I'm like, oh gosh, you're just going to be researching. So.
Okay, so this language unnecessary. You said there was language from you said the DC requirements that you thought.
Yeah, it was like, I think it was DC. It was extreme. It was like, and subject to discipline by the bar. You know, right? Like, I think that's a little extreme. Just maybe just like is responsible for the work of the CLS, just the general. Yeah, there was something like you could face disciplinary action.
Hey, Grant, thank you
I
for your
gotta
time.
go.
Grant.
I'm sorry, guys. I got a trial coming
Bye,
up.
Grant. Thank you.
Bye. Thanks.
Good luck with trial prep. Okay, so thank you guys for being here. I swear a lot more people said they were coming. Okay, I will, let me see. I have a link to this, if I can find the link to the DC rules. Assume full responsibility for guiding the student's work in any pending case or matter. Is that the language you were talking about?
Yeah. It's 3 cases for a trial on any given day is pretty standard. Wow.
Okay. Okay, so we can just lift this language. It's just, and assist the student to the extent necessary. That's kind of would be covered in the other matters we have. I think that flows nicely. You're going to provide training. You'll assume full responsibility to guide their work. You'll ensure their clients are noticed of their status. You'll review legal advice and pleadings. Make sure they're prepared and knowledgeable to handle anything. Make sure they have adequate oversight during trial or hearings, testimonial hearings.
Would you mind, could you go back quickly to the DC
Yeah.
rules again, just really quick?
Yep.
Oh. Okay, that's where that comes from. Okay. I was just looking at D because I mean, yeah.
It's interesting. I saw there's another standard that was more explicit, saying the supervisor or the attorney will be available for the client, right? If the client decides or comes up with a question for the law, right? If the law student maybe isn't prepared, like isn't comfortable answering, or the client just wants to speak to the attorney, that there will be a supervising attorney available within so much time.
I like that disclosure in like the initial client letter, like in consent form, and listing the supervising attorney and like if you have any, you know, whatever it is, concerns, if you need to reach me, here's like, you know, my phone number and email, you know, like no worries, like no, some sort of reassurance language where this is who you contact.
Yeah.
If you have concerns about the work on your case.
Well, I wonder if it'd be appropriate to have a standardized client consent form for public defense cases, right? That goes along with this, that this is the form that will be filled out and filed in any case a OPDC CLS enters. Yeah.
That would be so
Shannon
cool.
agrees.
Yeah, I love uniformity when it's possible. If we can have it, that'd be great. Yeah.
Right. And yeah, and you just get such a variety when you leave it to each office or attorney to come up with their own consent forms.
Mine would be like 10 pages long, unnecessarily 10 pages long.
Do you all have standard forms that you all have client signs for your CLS representation?
Yeah, but it's just like a 1-page
Yeah. Would you all just
consent.
And I'll ask some of the other attorneys or officers too, but would you all mind sending those or sharing those? That could be something that we work on, creating a uniform form as part of this. Okay. So what do you all think of that? I kind of just took it out, but that idea, that requirement of a supervisor being available for questions, maybe during again, like testimonial hearings, right? Things where things are happening right now. So making sure that there's somebody available or a supervisor is going to be available within so much time to a client. Is that something that is worth putting here, or is that something that is a lot for this requirement?
Because I kind of don't think it's necessary. And the only reason is that, like, for example, a lot of times law clerks will sit on misdemeanor, like a felony attorney has a client that's got both a felony and a misdemeanor case. The CLS is going to sit on the misdemeanor trial with that attorney. So that attorney can be there, but it's not the supervising one. And I think that attorney that's there is the one that actually has the relationship with the client that, like, I think is like the key part. And so I don't know that we need to make it that the supervisor specifically. I think that the kind of safety net that you're looking for in that kind of role is actually encompassed in some of the other, like, supervision things, like that the supervising attorney, ensures that their work product is good and that they have that the CLS has adequate supervision and, all of those other safeguards.
Let's see, I think we were going to take out this 3 trial maximum in place of just ensuring adequate oversight. Okay.
I totally agree with Kim. Like, absolutely. I think that flexibility needs to be there. And I'm just going to encourage it, if it's possible, to say something like where CLS is the lead counsel. I think that there should be supervision presence, or somebody that has been authorized by the supervising attorney to provide supervision for that.
Well, that could be maybe an offshoot of they have adequate oversight. So, like, where CLS is lead attorney,
For like court
supervising.
appearances, yeah.
Supervising, attorney will be available. I guess I could steal that language within a reasonable amount of time. If client wants to consult with them.
If there's if there's a, or I could see,
During
hey, can
adversarial,
if the court calls and is like, your student is like,
testimonial hearing. So,
is it okay if we put like another supervising attorney from a different PD's office on for those phone calls?
And they just pretend? You're like, what? That must be the other office's law student. Call Grant Cole. No. Okay.
Can we go back up to the the review and personally sign all correspondence providing legal advice? I'm concerned that is too much for personally sign all correspondence, because I'm thinking about like quick emails that a client might send, like, hey, what's my court date? What happens if I don't show? Like, that's such like an easy thing that law clerks should hopefully be able to address, that I don't think it would require a supervisor personally signing it. But I do think, like, anything filed with the court, yes, for sure. Because I think if there's anything bigger, like if it's like a trial letter, like, hey, you want to go to trial, but here are all of your risks, then the supervising attorney is going to look at that. I would hope, but I guess that's the purpose of these rules, to ensure it.
Yeah, I think, Kevin and I have seen a lot of.
We've had experiences.
Not what you'd hope in law student oversight as we've gained a wider purview.
That said, it may help when we were dealing with the paralegal work group. There's a similar provision. However, paralegals aren't licensed to practice, whereas certified law students, they've got a limited license, right? Like it's a grayer area. So keep in mind that that may be something that we want to either explicitly align or explicitly not align, right? Like certified law students are not going to be exactly the same thing as paralegals. They do have greater participation, like anticipated. And so do we want to supervise, like, is there, and if we're going to have like a level of correspondence requiring review by a supervising attorney, how do we define that in a way that we can put into the standards?
Yeah, I think that Kevin, thank you for that. I think that it seems that it would be helpful to mirror like the paralegal kind of limited practice stuff with the SPP stuff. If we're talking about CLSs, I mean, in reality, CLSs aren't going to have, they shouldn't have very high workload or caseload they're going to school to, unless there's some sort of externship, right? Immersive externship. I think that something like, like adequate oversight, or if we want to say something about oversight on all correspondence providing legal advice, are included on all correspondence providing legal advice, because it's not difficult to like, you know, send your supervisor a copy or to like BCC them on correspondence through email. If because I'm thinking about Kim's situation where the person is communicating frequently with the client and they're going back and forth, and then within our system too, our case management system, our clients can text directly, like text their person. And so sometimes there's just like quick text responses, but the supervisor will have access to all those messages and be able to review that as well. But for filings and pleadings with the court, and I would say, yeah, like something, if there could be something additional, like,
So let me put in the chat what we used for these are part of the role definition for the paralegal work group. Let's see if I can.
What about,
Dan, you're muted, so I can't tell if you're approving what we're saying or approving something that someone else is asking you about.
no, yeah, sorry, that was to Kevin. I really like that.
Yeah,
I think
me
that's really
too.
good.
Okay, so
Yeah.
we should have like a section on client communication, and we can. I'll make client communication. And so do you just want to steal this outright, granted change paralegal, or is there parts to change? So conduct client interviews. Oh wait, this would go under the law students.
And like as a note, this is not part of the performance standards for paralegal. It is part of the role definition. So these are tasks that paralegals are allowed to do.
Okay.
Explicitly. And so the way we set it up is there's there's 3 tiers. There's base level office support staff that are purely administrative, legal assistants who are primarily administrative, but also can do draft routine legal documents, and then paralegals who can do a lot more. And this is part of that list of things. And so each step is barred from doing anything that would require a higher qualification level.
You can mirror that here and move up into the role definition, the limitations, some of the limitations on law students.
I mean, I think that law students and provisional licensees might just be a further part of the spectrum of legal support.
Right.
Like it all could just be one category that we just use different work groups to define.
Right. Going to note here to put another section on court appearance.
I like what you just said, though, Kevin. I think that's makes a lot of sense.
Okay, this will take cleaning up, but I think we've mostly gone through this. So I took out, I'm in the middle of reviewing this, but like reviewing and personally signing all pleadings, motions, briefs, and other court filings prepared. That makes sense, not just all other documents, other court filings prepared by
Other documents. I think other documents filed with the court.
and then a separate to review, maybe just review all correspondence providing legal advice. Clients. Okay. All right, I think I can take this back and clean this up. So,
yeah, so, and then correspondence, can it be oversight of all correspondence? Because I think that, again, you know, if there's a CLS that's really, you trust that they're understanding what the parameters are that they should function within, then you can review like at night, right? You can kind of go through their cases and see correspondence or whatever, you know, or look through the emails, but reviewing everything ahead of time, I don't know if that's necessary. What do you think, Ken?
I like the flexibility of it being like oversight or
well,
I actually
review.
liked
Go ahead.
what you guys had in the paralegal stuff. Yeah, like yeah, under the supervision of an attorney.
Okay.
Because that could mean like you talk with the CLS beforehand and then the CLS goes and writes the 2-sentence thing.
Are you thinking of review, Christine? Are you thinking like review ahead? It could be ahead and after, I guess, because I was thinking of, in my mind, just like reviewing ahead, and then oversight in my mind means like you're overseeing like the whole thing, but maybe that doesn't mean anything. I could just totally.
Oversight feels more removed to me. Like, yes, I'm
Okay.
overseeing things, you know, versus review me, it seems to be more proactive, whether it's
Okay.
that night or later, but just kind of actually looking at it versus like, I'm overseeing this person communicate with the client. But might not even be necessary if we reorganize it up into the top. Okay, I'll just add a note. Oops, I never finished my last note. I'll put a note here. So when I was rolling into the supervised revisional licensee, I was struck with wondering in some of these, what we determine for the CLS is the bit of the foundation or the basis, and like how does that differentiate if right, you can use that as the foundation, and then what is different about a provisional licensee that you can make things different, or like whether it's more or less in certain ways. And so definitions are pretty basic at this point. We're just taken from the SPPE rules. And the qualification standards, and this, like we said before, we can maybe have this mirror what the CLS, what we did for CLS in terms of having practiced criminal defense for at least so many years or qualified by OBC for certain types of case types. So we can take that from above and meeting the qualifications means they will have practiced at least 3 of the last 5 years in a jurisdiction. We can make it Oregon specific for our purposes, like we did above for CLSing. You see, this is limited in scope to criminal, and we have ignored juvenile. So we need to make a note to also again, this might be a question more for our private attorney compatriots in terms of what the expectations should be for this is for supervisor. Expectations would be for how much time they spend on court-appointed cases. So obviously the SPPE requirement is that you spend at least 20 hours a week and a maximum of 40 hours a week towards your SPPE on cases. But an expectation that a certain amount of that is spent on court-appointed criminal cases. If you're in a firm that does hybrid work, are you going to be doing trust and estate work as well? And having some of your portfolio be on work in civil matters, or should it all be required to be in criminal matters? And that might honestly be a question more posed to folks that do hybrid work and are interested in hosting SPPE candidates for their input. This might be bits to flag for those folks. And this one too, in terms of requiring working for an organization or attorney that does a certain amount of court-appointed attorney work.
Yeah, but I do like the qualification standards for misdemeanor qualification that you all have currently.
Mm-hmm.
I like those qualification standards, but for SPPE, I mean, do you have somewhere else that says that they need to meet those qualification standards? I think the language in misdemeanor qualification is like or language. And I
Yeah.
kind of feel like that it should be and for SPPE folks. But this is that's kind of my own take on it.
Yeah.
I just think that ideally that when folks are like moving into SPPE, one of the big things that I like to point out is an SPPE pathway allows for folks that currently are representing clients as CLSs, allows them to continue that representation without interruption of the bar exam. And usually through your CLS experience within a public defense office, and I understand this is different for private practitioners, but you will have probably knocked out all of these, like not the judicial clerk one, but the other ones, the co-counsel. I think that those should be requirements for misdemeanor qualification, just because I think that takes care of commitment to public defense or commitment to public defense that shows that they are committed, and also is helping them just knock out those misdemeanor qualification requirements.
So do you think that, so by the time they should meet those qualifications by the completion of their time as a supervised, as a provisional licensee, is what you're proposing, versus you need to have these before you begin?
I think that you should, like, if you're looking for, because I saw that you're looking for commitment to public defense language, right?
Yeah.
Maybe maybe the only one is, it could be the or language would be the historical counsel for criminal trials or tried to a jury.
What about, so Jenna brought this up in the last meeting. And there was some pushback in terms of might create barriers to entry for some folks who had not had opportunities to CLS and not opportunities to do public defense before finishing law school for all sorts of reasons. It could be financial, because historically it's been unpaid. Me personally, I just didn't really decide I definitely wanted to do it until my 3L year. And so I was very passionate, but had no experience. And so people like me also, are very committed and could write a lot about it and why, but wouldn't have these requirements. What do you think about an expectation that you will meet these within a certain amount of time of beginning the program, or something like that, as a compromise? Or like, these are the expectations of what you will, so that when you are done, or at a certain point in your time, then you are qualified for misdemeanors without supervision, right? I'm wondering if that's a compromise. I don't know if it should be by the end of your time, by the time you're finished in your license, so that you are ready to go with misdemeanors, or if it should be within the first 6 months, but it might depend on how many hours a week you're putting towards it. There's a midway review. We could, for all SPPE folks, at the halfway point, they have to have their portfolio reviewed halfway. Maybe it could be at that point, there's expectations of what you've done so far towards your misdemeanor qualifications.
Like, I think that time period is a little bit generous. Again, I don't want to create barriers, but I don't think it's much of a barrier to ask someone to observe before starting. And I think that we should build in co-counsel trials, jury trials at the beginning. I think I'm just of the opinion that if you want to have your own clients being like lead on those cases as an SPPE person, I don't think that's a lot to ask of folks. Go ahead, Kim.
Yeah.
Sorry. I agree with you, Shannon, as far as like, we need to make sure that they have the adequate experience before they do it, especially if, there isn't some crazy bar exam to test their competency. But I don't know. I just think having the focus be on the jury aspect of it might mean that, because we can't control when cases go to trial and which ones end up in front of a jury versus a judge. I kind of think that having it be like, 5 complete trials, or, with at least 2 to a jury, and co-counsel on at least 2 trials, 1 to a jury, or there being something like 3 motions that required testimony, because like a motion to suppress basically could be what your Dewey trial is, just not to a jury, maybe. So I think kind of opening the what types of hearings and activities would qualify would be helpful, but I agree that there needs to be kind of a robust amount of experience before saying, here's your caseload, you're your own attorney.
Yeah. Well, and what is y'all's understanding or feeling about at what point in the SPPE you're saying you're an attorney, have some cases? Because for me, I feel like there's this significant amount of training where you're not that person yet until you have completed, and then you're barred. You're still under supervision, like a CLS, but with more autonomy and more like set out goals and practice and things like that. So I guess I'm going back to timeline. Like when are you all thinking is an appropriate time to expect this of folks that are going through this exam? This is just a very long exam, right? This whole provisional licensing.
Like, I think that someone should be able to like be able to reach those misdemeanor minimum qualifications prior to full licensure by the Oregon State Bar. Because for instance, like we've had CLS in our office that have done all of these things, right? So that's what I'm thinking, like they've already done all these things. They're more qualified than somebody that is studying for the bar, takes the bar, and then comes into the office and is waiting for their license. So I don't want to hold those folks back when they have already met these markers. So I don't want it to be, I don't know. Does that make sense? I'm just trying to, like, for instance, like if I have a really like a solid, I know not everybody has like a Jana Baker, but Jana Baker is like pretty much staff co-counsel, not technically, but like on 4 Measure 11s. This will be her 4th today, and like the other 3 like ended up in acquittals because of her enormous support and research ability. Like, and just she's just like spot on with objections and arguments. And I'm just like, who is this person? I know not every office has that, but like I would feel very comfortable with Jana Baker taking like, starting off with half a misdemeanor caseload, and maybe somebody else I wouldn't. So I think there needs to be some flexibility. But I wouldn't know that about Jana Baker unless she did like have this experience that we're talking about.
So I guess we could say if there could be a different expectation if somebody was a CLS versus they were not going into SPPE, right? Or different, I guess, limitations, I guess, is maybe more what you're after. Is they're able to take on more factor if they have met these qualifications. So we could do something about when an SPPE person has met these qualifications then. And that way, if it's a CLS or a rock star that comes in and does it all, like then it's like a mini goal inside SPPE. Say I've hit all these markers, so now I get to take on more. Now there's something else happening. Versus, I don't think there's any clear way to delineate it otherwise.
Yeah, I just want to say too, like, I think that you can learn that through like a really contested motion hearing too, right? Like you could learn that from a trial to a judge. There's different reasons that you want to have a bench trial versus a jury trial. So you wouldn't like want to provide an incentive for a jury trial for a CLS or for an SPPE versus a judge trial if it's worse for the client, like you don't want to do that either. But I think you would learn the same information, like Kim said, from those substantive adversarial hearings.
Program is completely separate from like anything having to do in juvenile world? So like CLS, it at a juvenile firm would have a different set of standards.
Yeah, we'd have to do it that way.
You all have the language for that, right? For dependency or for.
I mean, it's that, let's just put it this way. That's a much larger barrier to entry into, so delinquency, it's straight up very similar. Not a huge difference. I mean, there's some technical differences, and they are important, but oh, that's not the document I wanted to open. But for dependency, delinquency is just like have a couple of bench trials and be, we need to revamp this because you're technically supposed to be, or at least the most common route is be criminal misto qualified and then do a couple of bench trials and you're juvenile misto qualified, which is not great. So, but for dependency, I mean, in theory, you should be lesser felony at minimum, I think. Let's see, 7A. Where is it? No, that can't be right. Why is it not? Okay. Need to be at least delinquency misto or criminal civil or equivalent civil or criminal experience, and then have 2 dependency cases adjudicated or observe 5 dependency cases adjudicated. Yeah, it's a heavy lift. So, and I mean, part of that is because the procedural trappings are so much less consistent, and the substance of what you can see in a dependency case is all over the place. So I don't know. For delinquency, it would be the same, like just be misto qualified.
Delinquency qualified.
Yeah, I mean,
I'll write the language later, but delinquency. No, that's not right. Delinquency.
ENCY.
Yeah.
Is there a reason why qualification under supervision would be inappropriate? Because that's how most people start off with juvenile certification. There's not a huge amount of opportunity as a law clerk to do dependency work. It's out there, but it's way less common. I don't know of any clinics that do it.
So we should maybe hammer out what that would look like for it on the juvenile side.
Yeah, I think that's how you get qualification, Kevin, is it has to be under supervision qualification.
Which to me, I mean,
yeah.
they have to be supervised anyway. The supervision may be of a different, like the requirements of the 2 different types of supervision may be different, but they're already under supervision.
It's also a really interesting bar there because it might be interesting to say like that whole with judicial applications, like 3 recommendations or letters of support from opposing counsel. Like you could do that in this situation for juvenile practitioners, because they're all the same bar. They're not, they represent parents or children all together. I don't know. It is very different though. I defer to the saints that do juvenile work and the sinners that do juvenile work.
Just making this note for later. That we're not making it like a barrier to entry, but it will affect your role or the expectations there.
Yeah, because I think also in the back of my mind, I think about, not that there's anybody specific that I'm thinking about, but say there is an administrator that would just be looking to like offload a bunch of work and just like kind of get like really cheap labor, right, from these SPPE folks, and they're not getting the support, which I know is none of my business, right? But it is your business. So
Right.
I just think that they should be investing and yeah, just like facilitating these learning experiences for them.
So yeah, so I could envision having an SPPE misdemeanor under supervision qualification level that you need. So so before that, there's, they cannot appear, outside of regular CLS rules. Once you've done that, then we can allow a little bit more in terms of what they're allowed to do. Like maybe before then, they're never allowed to be alone or something. Or like have, but we can't make it more restrictive than what CLSs can do. But yeah, okay. So we can noodle with that and think of what can the shifts be and expectations be before and after you've met that as a provisional licensee.
Yeah, that's
Okay.
great. That's awesome.
Okay. So okay, 2:42. I appreciate all your time on this, you guys. Very much appreciate your time today. And I kind of, with the supervisor role for SCPE, it's another time where I felt like it's going to fall back on a lot of similarities to a CLS supervisor, but maybe with a little bit less mandatory, or maybe again, this will be a before and after they've reached their qualifications thing. Adhere to the roles and duties. Like this one, only delegate supervising attorney duties to attorneys who otherwise meet those qualification standards. And I think that's kind of involved in the SCP rules anyway, but I think it's important to call out. You can't just throw your SCP person to your misdemeanor attorney to supervise, which we've seen happen with some CLSs, right, and things like that. Otherwise, I feel like a lot of the supervision will be similar to what we had for CLSs in terms of providing training, assuming responsibility for guiding their work, ensure their clients are informed of their status. Some of this, the reviewing correspondence and signing motion. Well, signing motions, I think, will probably still be required before they're licensed.
Oh,
Making sure they're
that's
prepared.
probably something we need to check with the SPPE rules, don't we?
Yeah, I'll check it. I mean, you have to follow the CLS appearance rules, just not all the qualifications. But yeah, I will.
There are some differences. I don't remember. I can get it out, but like I think there are some differences. It looks like.
Mission roles and duties. You must adhere to the constraints specified in the temporary supervised practice rules as they apply to law students qualified under this is the law student appearance program.
think that every SPPE in the public defense office needs to complete evidence. I don't see there being an exception for that. Like same thing with the NPRE, right? I think that, anyways, ethics and evidence. Uh,
Okay. Well, I guess this is a requirement that you've taken it or your supervisor has agreed you've made up for your lack of. I guess they have to give a carve out because if you just somehow manage to miss evidence, they have to give you some way to catch up, I guess.
Can you graduate law school without taking evidence?
I don't know. I was aiming for law clinics, so I don't remember if it was actually required otherwise. You just needed it to be able to appear to do law clinics and appear.
I mean, I think from a liability standpoint, I don't know what state liability is, but from like a liability standpoint, I just can't imagine saying, oh, there's an alternative to an evidence course. There's, we'll insure that through a CLE. No, we'll like supplement that with CLEs, but I think you have to have a basic, like a law school experience. And I think evidence was one of the few law school classes that were actually like, yeah, that actually made a difference. And I think it's part of, to get a CLS, I think you have to take evidence, right?
Mm-hmm.
Mm-hmm.
So
Evidence and NPRE or profession or the ethics class.
Yeah.
Okay, qualification.
That's weird that they don't have that there. It's like you can be I don't know, maybe I need to get out of this hierarchical.
Not everybody who is doing the SPPE program will be a litigator. So evidence, I mean, Turnquist was really clear. Evidence is like core. Everyone should be thinking about it whenever they're doing anything, because when you create a contract, you should know what's going to be able to be introduced at a hearing on this. But
Okay, so maybe we do the same evidence and ethics requirements that a CLS has.
I think it's worth it to break with the SPP rules so that we've
Yeah.
got a standard specific to public defense practice. And I can't see somebody being effective in this program without that.
Yeah, no, I think there's reasons why, like you were pointing out, why you might be able not need to meet CLS requirements to complete SPPE, but for public defense, you need to be meeting those like what you would have needed to certify as a CLS. So I think that's right. And clean that up, but the same. Okay. And then I think there's some things that I think you're going to have to, again, go to the private folks in terms of, will we have requirements that your SPPE obligations will be met through court appointed cases, or how many of them need to be met through these cases versus you're also going to handle a civil matter. You're also going to handle something else if you're in a mixed caseload environment. So that might be something to take to those folks. And then we can start thinking about what might change for an SPP person before and after they've met those misdemeanor qualifications and a misdemeanor, being qualified for misdemeanors under supervision, and how that is different from being a CLS, basically. Like before that, you're basically a CLS, and then you graduate to what? So we can start working towards that in a future meeting. Because I was saying at the beginning of this meeting, I think it was maybe just Grant was here at this point, that our timeline has opened up. So we think we're going to have more time to before this has to go to the commission. I mean, I think the initial communications was that this needed to go to the May commission so that they had it before future stuff in the June commission meeting. And that timeline has changed. So it looks like we're gonna have a little more time to develop these standards for all of the support stuff than we initially thought. So I want to say might be a good stopping point for today. I think that until we figure out that delineation, a lot of the super.
Can you try really hard to put it in front of the commission in May? And then when they have more questions and want you to further explore other things, you can come back in June?
So I think that
I think we will be presenting these topics at the commission meeting in May, and we will be giving them up an update. We will probably not be submitting this as a final product for the commission meeting in May. That is kind of the murmur that we're getting is to the change in the timelines.
Okay.
So,
yeah, there's just so much interest in this program right now. And it's like, God, it's like watching, I don't know. I know you probably understand what I'm talking about, but it's just like all these folks that we could just have ready to like rock and roll by, probably pretty well by August, September in this little protective training bubble. And it's like, and then they're going to go somewhere else or, because you can do a conditional, like you can do a conditional offer for employment. You can have folks agree to like, as an employer, you can have them agree to stay on for a certain period of time or like do a hiring incentive bonus, like that diminishes over time, right? It's like this opportunity. I'm just like, there it goes, so I just needed to say that. I'm good.
No, and hopefully, I think that getting like these standards to the commission, I think is not what short-term SPPE funding depends on. I think this is more geared towards having a product to bring forward to get long-term funding for these positions in next year's session, right? And so I think that is different than the viability of a smaller pilot or something like that. But yeah, getting this drafted into a final form in front of the commission, this week, I think we would welcome more time to hammer these out. But yeah, I think this is separate. This is more for long-term planning.
Thank you. I know you're working really hard. I know you and Kevin are working really hard on all of these and care about this very, very much. So I know there's only just a few of you to go around.
It's 2:53. So right with you all, maybe I think we're at a good stopping point. I think you've given lots to think about, and I can majorly clean up that mess of editing I just made for myself, and then bring this up again and also highlight for some of the private attorney folks the things that we want their input on. Otherwise, the nonprofits will decide it for them. And circle up again, hopefully.
Shannon, totally off topic, but while I have you, I got to spend time with Jana at the Trial Skills College over the weekend, and she is awesome. You got a great find there.
Yes, she tells everybody that she meets that I stalked her to get her to come to DMC. So you probably heard that story, which is not great for my reputation. Thank you, Kim.
Yeah.
Sorry, Laura was eavesdropping this meeting.
I just really want to say you, Kim. Hi, Dennis. And good to meet you, Christine.
Laura's stalking me, so okay.
Yeah. All right. Thank you all.
Bye, everybody.